Hello.
How's it going?
Good.
It's been a moment. How you doing?
Oh, it's just a great time.
I gotta say, I am in awe of all the work you're doing. Like I was saying to people before, we worked together a long time ago now at BuzzFeed, really long
Yes.
time ago now, and you've been doing great work on the legal beat since. And since you launched the Substack Law Dork, I gotta say it's become pretty uh, necessary. It's been unmissable for in terms of just understanding what's going on with the Supreme Court and district courts and kind of reading between the lines. I'm not a lawyer, and so you are, and so you obviously understand this stuff a lot better than all of us. So, especially now of all times, really glad to have you here because you must be exhausted. So,
It, it's uh it, it's interesting because I have this idea that we get all of the decisions and then it's going to be summer break. And like there are two reasons why that's not the case. And the first is that so much of what they do, um, either intentionally or because they're just poor at doing their jobs,
both.
leads to a ton of follow up immediately after the fact. And then, like, sort of a good problem is like this, that all of a sudden the week after the court's out, everybody wants to talk to me about the court. And so I'm thinking oh, we got all the decisions on Friday. That at least means that we're done with the court. But this week it's every day is now talking about the court, which is
Right.
obviously a great opportunity. But it's interesting sort of how uh in fact, sort of being independent has changed my view of what the end of the term, when
Right.
it actually is. And it's really more like 2 weeks after the end of the term, once all of the term and review conference panels and
Right.
stuff are done.
Well, and certainly like with this administration, is never time able to stop
Well,
doing
yeah.
anything.
I mean, and that first issue is just I mean, we're gonna be back at the Supreme Court. I mean, we'll talk more, but
Yeah.
I mean, we're gonna be back at the Supreme Court with something in the 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 birthright citizenship case
Right.
before the end of July.
Yeah, and it seems like a lot of their decisions, especially on Trump issues, executive orders, and whatnot, have just sort of like been technical decisions that have opened the door to some terrible things for a period of time until they actually deal with the actual issue at hand.
Yeah, they don't want to deal with the actual issue at hand. And so because it would mean either dramatically upsetting law to create more problems than they want in order to do what Trump wants, or upsetting Trump.
Right.
And they clearly don't want to do either. As long as they can put it off, they're going to try to do that.
It's interesting. John Roberts has spoken a lot about being, all the attacks on judges and whatnot, and clearly they fear that. But are they really afraid of Trump? What do they have to fear? They got lifetime jobs. What are they worried about? Just people sending them hate mail?
I mean, I think they are. Um, I mean, there's sort of the truism about the Supreme Court has neither the power of the purse nor the power of the sword. They have the power of their judgment, and at the end of the day, that doesn't get you far if neither of the other branches are willing to back you
Mm,
up. And so I think um, there is a real concern whether or not it should dictate their behavior is a second level question. But I think there is a real concern, sort of essentially. I mean, think if you I mean, this isn't a boss because they're supposed to be equal, co-equal branches. But think about if you were working in a job and you had a bad boss, and whenever
been
you
there,
came to him with a problem, you were going to get an out of totally out of proportion response.
been there.
You sort of you sort of cut your losses sometimes.
Right.
You don't bring everything to him that you really want to, and you really mean it when you do.
Right.
And I think that that's essentially what, at least for the middle group of the court, uh for Barrett and Roberts and sometimes Kavanaugh, that sort of their view is, I mean, looking at what they did with it, it was back in the last administration, but what they did with the emergency room care abortion law, EMTALA,
Right.
where they sort of split in thirds, and you had this middle third that essentially didn't really resolve the issue, but sent it back down, didn't give the conservatives what they wanted, but didn't really uh, issue a final ruling interpreting the law.
Mhm.
And so it sort of kept the legal issue floating out there, but didn't give the conservatives what they wanted either.
Right.
And that's sort of, in a way, depending, and that's why you're sort of seeing people talking both ways about last Friday's
Mhm.
ruling in the birthright citizenship case. You're certainly hearing people saying this was as bad as the immunity ruling. This is a horrible end time ruling. And then you've got other people who are saying eh,
Right.
this is more of a technical ruling that it gives Trump what he wants, but it doesn't ultimately sort of change the lay of the land. The truth is, neither of them are really 100% right,
Mhm.
because the actual answer is going to come in some of the questions that the court left unresolved still. And I mean, not only the ultimate issue of, is the birthright citizenship executive order constitutional, but even
Right.
the question of are people going to be able to challenge the birthright citizenship executive order with class action lawsuits,
Right.
which was sort of one of the reasons why the court on Friday said it was fine to get rid of nationwide injunctions, because when necessary, you still have the ability to have class certification and class action lawsuits that can have broad relief.
It seems wild to me that, it's this is there's so many things that are wild to me about this court, but I mean, the 14th Amendment couldn't be more clear, right? It couldn't be more clear that there's birthright citizenship. It's just been the staple. It's been, keystone of American democracy and rights for so long. And, you they, like you said, they didn't rule on the actual issue of, is this can you get rid of that or not? But it seems like, you know, there in 30 days or less than 30 days, it's sort of like you can do a little ending of birthright citizenship like on
Yeah,
a
they
treat until
did.
we
Yeah, I mean, technically, and this is that whole issue where you get into what did the court technically do versus the real world effects.
right,
And that's sort of what I wrote about at Law Dork on Sunday night, was this
right,
reality of Roberts doesn't seem to see the real threat that people are facing from these rulings. And but then you go to the other side, and it's technically, Justice Barrett's opinion on Fridays made clear they were saying nothing about the constitutionality of this executive order. This is all about the scope of the remedy. And
right,
so it wasn't even normally when you're dealing with shadow docket requests that we talk about, these applications for relief that come up quickly to the Supreme Court. Normally, when those come up to the court, you're asking for a stay of an injunction below, or an injunction where a judge refused to give an injunction. And so you're either asking to stop a stop or to stop a law or
okay,
policy. And the one of the standards for that is, one of the four parts of the test is the likelihood of success.
right,
And so normally on the shadow docket, there is a part of what they're looking at is, and you'll hear justices talk about this sometimes, taking a peek at the merits, that there is even though it's
Mhm.
not a ruling on the merits, like they are looking at it. But here in this case, they got even out of that because they weren't even hearing on the shadow docket a question about the injunction. The Justice Department, and this was what Justice Sotomayor criticized harshly in her dissent, is that the Justice Department didn't even ask for a review of the injunction so that they wouldn't let the Supreme Court take that peek at the merits.
Right.
All that they brought to the Supreme Court was they said, we're questioning the scope of the relief, the scope of the injunction. And so the only likelihood of success that the court was looking at was, what is the likelihood of success that the Justice Department would have if they took up an appeal of the scope of the injunction?
Mm.
And so, like, that's why Barrett was able to get away with writing a majority opinion that could say, we're not looking at whether the executive order is constitutional at all.
Okay.
So it was sort of like a sneaky move from the Justice Department that the Supreme Court knew exactly why they were doing it. It was clear at arguments on May 15th, and yet the majority said, yeah, we'll go along with that for now.
And so we have this situation where for the next 30 or probably 25 days or something like that, people don't really know if you're born to an immigrant or someone who wasn't legally here, they don't know what the situation is going to be in 25 days or a month. Like, yeah, we know the Supreme Court's probably going to rule on it at some point, but what a way to exist.
Yeah, right now we have by my count, and there might have been new lawsuits filed today, but we have these two cases that involved multiple groups of states that are suing. One New Jersey-led case in Massachusetts, and one Washington state-led case in Washington state. And in both of those cases now, they're going to go back to the lower courts to decide, in light of the Supreme Court's ruling, were the nationwide injunctions granted to those states appropriate? Because in those cases, the states argued that those weren't even a normal nationwide injunction. They said that in order to protect even the states that sued, you need to give a nationwide injunction because of the fact that people travel so much,
Right.
because of the fact that, like, the one example that came up at the Supreme Court, came up in the arguments, was and they sort of, New Jersey sort of play, the New Jersey, Pennsylvania, they like fighting each other in the Eastern Pennsylvania, the Philly, New Jersey fights. Because of the fact that Pennsylvania elected a Republican attorney general, they didn't join these
Right.
lawsuits, even though they still have a Democratic governor. And so, in the arguments at the Supreme Court, the New Jersey Attorney General's office was arguing, and they were like, so what happens? You've got New Jersey, lots of people, thousands of people from New Jersey go over to Philadelphia every day. What happened? There are thousands of babies of New Jersey residents born in Philadelphia every
Sure.
year at Philadelphia hospitals. What happens to those babies? Are they not American citizens because they're born in Philadelphia? Are they not American citizens until they go back home, until
Right.
they're released to the hospital? Then let's deal with the fact that in almost every place, your social security number is assigned, like, at the hospital when your birth certificate is filed
Sure.
by the hospital. So what's going to happen to those New Jersey babies who are born in Philadelphia? Like, and essentially the Massachusetts judge said, good point.
Right.
Like, that won't work. People also move. Does
Sure.
that mean that, like, at 3 years old, your family moves to New Jersey from North Dakota?
Right.
You are still not a citizen. How does that work for benefits? How does that work for, like,
Vice versa.
all of
Right.
these questions? Yeah. Uh, and so, yeah, so those are going to be happening in those two cases. Then in Maryland and New Hampshire, there are cases the CASA case that was before the Supreme
Right.
Court, they immediately moved on Friday to amend their complaint to make it a class action, to ask for class certification, make that a class action lawsuit. The ACLU filed a lawsuit in New Hampshire. That is a brand new lawsuit seeking a class action. And so you're going to have all four of these cases, two multi state cases, two potential class actions that are all working aware of this timeline that you just laid out, this 30 days to roll on it. And already today, in both of those potential class action cases, the judges moved quickly. They held like status conference, not like hearings on the motions, but
Right.
like conferences today to set up timelines for briefing to consider this. And it's basically over the next week. Like by July 10th, all of these in both of the class action cases, they're going to have briefed the class action ready to have a hearing. And so there are probably going to be hearings by, if not the end of next week, by definitely the Monday after that, and probably rulings by the Friday after that, which will then, assuming one of those cases gets class certification and it's nationwide, their DOJ will appeal that to the I guess it's the First Circuit or the Fourth Circuit, and then you're going to be back to the Supreme Court before the 25th.
It feels like I'm taking crazy pills when we're even talking about this. Like it's so if you can have an executive order that says this constitutional thing, this thing in the 14th Amendment on the Constitution doesn't count. Like it feels like that's kind of a ball game in a lot of ways.
Yeah, I mean, DOJ argued, I mean, it wasn't relevant to today's argument, but the DOJ lawyer who was Brad Rosenberg, who was in the CASA hearing today, said at one point that, like, the government's view is that the 14th Amendment does not protect the citizenship of the people who the executive order would exclude. So they're essentially arguing that when it gets to the merits, they will say there is no such thing as birthright citizenship, that the Supreme Court was wrong from the get go when they heard the Kim Wong case. The Congress was wrong in their interpretation of that when they passed the Immigration and Nationality Act, and that all of the court rulings since then that assumed that the case and law were wrong. And like the thing is, when those class action cases that I said are going to come up, if the Supreme Court would decide not to accept those class certifications, we could be back in the same situation with a Supreme Court ruling just on the scope of class actions that then sends it back down to district courts, and we're back on another 30-day stay.
And in the meantime,
It's all absurd. Yeah,
and in the meantime,
everybody's waiting.
everyone's waiting, and comparing things with Nazi Germany is cliche at this point. But it reminds me of the Nuremberg laws, right, where they just kind of kept taking away things and citizenship from Jewish people, right? It was just like, actually, you're not citizens anymore. And now we've got DOJ also looking at denaturalization, and it feels like we're getting closer to, again, I don't like to fearmonger, but I don't know. We're at if the frog's boiling, if frog's in the water, the water's pretty hot at this point.
Yeah, I mean, I'm one of those, like, I'm sort of the I've always got the thermometer and I'm looking at it and I'm always worried. But then, like, I'm always going to point out, like, oh, it went down a half a degree today. Look
Right.
at that. Isn't that great, guys? And it's not that it's great, but I think that the important thing is that, like, it's great that people are throwing ice cubes in the water.
Right.
And I think that that's the point. That, like, I like highlighted it today because I had missed it in the course of the Supreme Court rulings on Friday. But, like, on Friday afternoon, another judge in DC ruled that another one of Trump's executive orders targeting law firms was unconstitutional
Mm,
and issued a final judgment. It was the one targeting Sussman Godfrey. And so that's now 4 district court judges appointed by presidents of both parties who heard 4 different cases targeting 4 different law firms, got 4 different sets of evidence, and issued 4 different final decisions saying these are unconstitutional. This one from Friday used the same language that the executive order is null and void.
mm,
And I mean, that's good to see.
yeah.
Like, bluntly, like, it is good to see that, like, you've had 4 different judges, that got these cases and looked at them, took them seriously. They didn't consolidate them. The law firms wanted them all before one judge, and I think, like, while that might have been nice and we would have all liked that, like, I think at the end of the day, with how it went forward, that was probably a smart move. Like, let 4 different judges get all of this evidence before them and let DOJ try to defend it 4 times, lose 4 times. And, like, DOJ just filed their first notice of appeal
Mhm,
in the first one of those cases, Perkins Coie, today.
right.
And I think they were waiting to see if they could win one.
Mm. And
Like,
now it's
because
they have 4 against them,
they
that's pretty good.
waited, like, the DOJ has 60 days to appeal.
Mm,
They literally waited 59 days.
right, I saw you mentioned that,
And
yeah.
so, I mean, I think they were hoping to win one so that they could go up to the DC circuit or force a law firm to go up to the
Right.
DC circuit seeking an appeal. And they weren't able to. And so, like, I get that a lot of these things are bad. Like I pointed out in last night's piece about John Roberts, that, like, in light of the way that they resolved this, like, no, it's not good. It's bad. I wrote on Friday about how bad it was. But, like, where we're left, the thin reed
Mm,
of hope that we've got is that, like, conservatives haven't liked nationwide injunctions. They got rid of them, but, like, eventually they're going to be forced to deal with the merits of this.
right.
And let's hope that when it comes to that, that there are 2 or 3 more votes. It seems like Kavanaugh is skeptical.
Okay.
Um, he was sort of the concurring opinion on Friday, who kept talking about all of the other ways that courts could deal with these things. And he was even saying, like, the Supreme Court can, like, weigh in, and he used language like de jure or de facto,
Mhm,
create a national precedent. So whether they're creating an actual rule for the entire country or whether or not they're creating just a nationwide precedent that literally anybody else to bring the lawsuit would be able to win, that, like, the Supreme Court can do that in short order. And so I think that that is at least a hopeful sign that maybe he wanted to do that with this case and wasn't
yeah,
able to get a second conservative to be willing to do that now. Um, and again, that could be given the reason that I was talking about, that, like, DOJ only asked for the scope of the injunction to be brought up. And so, like, technically the issue of the merits of the executive order wasn't before them. But at the same time, like, I think that that's the hope that we have. But I said, like, that is our thin hope.
right.
Like, if the Supreme Court were to allow any of this executive order to go into effect anywhere in the country, it is an astounding abdication of their rule.
Right.
Because, like, many people now, 5 lawsuits that have gotten significant attention. There might be other lawsuits that just haven't gotten the attention, but at least 5, like, well represented lawsuits that have gotten significant attention are pending are going to be uh, front and center before this executive order goes into effect in 30 days.
Would it
And
surprise you if they let some of it go into effect?
I hate saying surprise at this point because, like,
It's hard.
I truly, I mean, I thought, like, I'll say, like, I mean, I didn't try to hide from it in my Friday post. I still linked to the oral arguments. I did not think they were going to do what they did on Friday.
Right.
I thought that they were going to dramatically scale back nationwide injunctions, but I actually thought what they were going to do is say, like, nationwide injunctions are like should be rarely issued, and this is the rare type of case that merits it
Mm,
because it deals with immigration, which is the fundamentally national character. And they could cite to other cases where the court has said that. Look
right.
at like how the court has handled like challenges to DACA, challenges to even some of Trump's some of the like the travel ban and stuff like that. Like there's good language from
Mhm.
like the past 10 years from the court, not in these sort of cases about nationwide injunctions, but in cases about immigration where like the court has talked about the nationwide character of immigration. And they could have said, like, nationwide injunctions should rarely be allowed except in cases where there is I mean, you could even throw Clarence Thomas a bone and say where there's a history and tradition of the court understanding the nationwide character of this issue and that piecemeal injunctions would be unworkable. Like, you
Right.
could have said something like that, and it would have been clear that in most cases, this this would now be gone, but it would still be appropriate here. But the court didn't even say that, and they got rid of them, and they're now going to deal with the consequences of that, both in this case and all the problems that we've already talked about, and they're going to deal about with it outside of this case because
Sure.
they now are going to deal with all of these questions that Alito and Kavanaugh uh, and Sotomayor wrote about on Friday with these questions about how class actions are now going to proceed. And Alito warned, like, don't let class actions become a loophole to today's ruling. And he was like, I don't want anybody to be able to get relief when I don't want it.
Sure.
Um, and then you're also going to deal with this side question that is quickly going to become an issue of the Administrative Procedure Act. And that's how you challenge regulations.
Mm,
Whenever an agency issues a regulation, um, that's generally the way that you see it challenged because you can bring a challenge under the APA. And one of the remedies for that is what's called vacatur. And Justice Barrett dropped a footnote into her decision that basically said, we're not deciding whether or not vacatur can be nationwide.
so no one knows. Yeah.
And, well, I mean, think about it. Like, if you challenge a regulation, you're literally bringing the lawsuit against
Right.
the secretary of whatever department issued the
Yeah.
regulation. And if you win the lawsuit, the law says that you can get vacatur. You can vacate the rule, which is what it sounds like.
Right.
But now the question is, does that mean the rule's only vacated as to the plaintiff? Or does
Mm,
that mean what we've always thought it meant, which is that the rule
overall.
is vacated?
Right. Because they like
And
vacating
so
rules. Maybe not.
they like vacating
Yeah.
rules, and that's Matt Kazmarek, the Northern District of Texas judge. That's what he tried to do with mifepristone,
Right.
the medication abortion. He was using the APA
So they've used a
there.
lot of this, right? They've used a lot of
Yeah.
injunctions on stuff that Biden did with their student debt or other things like that. And so that's sort of the I mean, people are talking about this on Blue Sky on Friday. It's an element like, all right, well, fuck around and find out, right? But then I
Yeah.
would imagine that the court, because they allowed those things to happen, aren't going to so easily say, oh yeah, those things are vacated.
What's question like so we've got those two, and then there's this issue that now the multi-state litigation over the birthright citizenship order is going to get into, that they talked about, that you're able to provide complete relief to the parties withstanding that suit.
Hmm.
And in those cases, because of the whole New Jersey, Pennsylvania thing, they weren't arguing that this was a normal nationwide injunction. They were arguing we need nationwide relief in order to get full relief for the harms that we're claiming. And that's another, and that this issue of third party standing is the other potential loophole that Alito warned about in his concurrence.
Mm.
And that's now going to, the first time that that's going to play out is when these two, the New Jersey and Washington cases, go back to Massachusetts and Washington, and they sort out, was nationwide injunction appropriate
Right.
in those cases. So that's going to now happen in every case as well, where states and others, I mean, it's not just going to be states. There are
Sure.
going to be other groups and entities that try. The Supreme Court did try to give short shrift in a very short paragraph. And this is one of those things. This was a shadow docket request that they set for argument, that was argued on May 15th, and the decision was handed down on June 27th. That, like, that's not the right way of doing this.
Right.
That, like, in one paragraph, the Supreme Court basically said that it's never going to be appropriate to give complete relief because an organization says that we have members nationwide.
Hmm.
Now, like, there are situations where, and this was a big deal. This was a big deal in the civil rights era, where, like, the NAACP asked for broad relief because they said we don't, our members don't want to all name themselves.
Right.
They're going to literally get attacked if they, like, put their names on court filings. And courts understood that. And so, like, I mean, think about this. If you've got, um I mean, if you've got, like, I mean, who knows what's going on with trans people's rights at this point? But, like, if you do have trans people in litigation in a case, like, even if it's in a state where they're bringing things, where they have more rights under state law, and they're bringing a federal action, for some reason, like, do all the members of that trans organization need to have their
Right.
name uh issued on the court filing in order to get relief? Because, like, that's going to potentially, depending on where they're at, put them at risk.
Yeah.
And it was all handled in, like, one paragraph in a Supreme Court ruling based off of, like, not even 6 weeks of time to consider it. And I think it was like, while we rightfully criticized the fact that the court didn't really resolve anything with this
Right.
decision last Friday. It's, in some ways, it's really disturbing the things that they did resolve with very, very shallow briefing on the propriety of, like, a final constitutional ruling on that issue.
Right. And I wonder, like, when I think of there's been so many nationwide injunctions. So does this put all of them now at play if you sue over them? Like,
Yeah,
what does
well,
it mean for
that's,
so many of
I
them?
mean, I've been talking about that. Like, I think one of the things I was talking earlier today, like, you've got, like, permanent injunctions that were issued 5 years, 10 years ago in some cases. Like, what if there was a nationwide injunction issued 5 years ago? Like, somebody going to go to court and argue that that was issued illegally,
Right.
and that case needs to be reopened, and the even forget nationwide, like look at the language of the court saying like no greater relief than the parties have, like even if it's like a statewide injunction that was issued in federal court, like there's got to be hundreds of those out there that are permanent injunctions that are just in place that have, in most people's mind, led to state laws being
Hmm.
considered unconstitutional. Like what happens to that? What happens? I saw somebody on Blue Sky today was like, "What about Mahmoud, the school book case, or the not school book, the LGBT books in
Right.
school
Right.
case?" Um, the does that mean that that injunction only counts for those parents and
Right.
the members of the group that sued, Kids First or whatever ridiculous name
Yeah.
they gave, Saving Children or whatever? Like does every classroom that has no plaintiff children in it, are they not
Right.
held applicable to the Supreme Court's ruling?
Yeah. It seems
Does
like it can
somebody
go both
need to
ways, right?
file a
Like
lawsuit?
it
It,
can go both ways. Like conservatives could have their causes damaged, but it seems like that's not the intention here from the court.
like, of course, you do have a Supreme, and this was sort of Kavanaugh's point. Like, you do have a Supreme Court precedent, and if anybody brought a lawsuit, they do automatically win. But the other side of that is like some people don't have the wherewithal or the ability to bring a
Right.
lawsuit. They don't have the knowledge. They don't have, like,
The
not
money.
everybody read that Mahmood came down. Like, forget, yeah, like, sure, they could just, like, if they knew, they could reach out to ADF and get Alliance Defending Freedom to represent them tomorrow. But, like, they're not going to know ADF exists. They're not going to have money. They're not going to know the ruling came down. Like,
Right.
do they know that they have this new protection? It's like very easy for like Kavanaugh to say like, oh, we have de facto, we've issued a ruling that means like, in fact, it's out there, everybody knows it.
Right.
But
We
that's
live in a
not
bubble.
true. Like, there are, like, you look at any survey, like, there's 10% of Americans who don't know anything. There's something that the rest of us assume everybody knows, that, like, 10% of Americans will be like, I thought the answer was B.
Yeah, I mean, that's the thing, and I don't know if they and it's hard to read their minds, right? But it seems like a lot of times they're answering on these technical questions and not considering what's gonna happen in the real world. Maybe they're just so removed from the real world that they just, like, don't even,
Yeah,
realize
I
what's
think
going
there
on, but
are some, and that's like, I mean, I sort of like dove in as hard as I could to that last night, like
it was a great
talking
piece.
about the sort of like the disconnect between sort of the flippant almost way that they handle immigration decisions versus sort of like Chief Justice Roberts over the weekend talking about the serious nature and how political people need to be careful about the words that they use when talking about the justices because of the danger that judges can face from their decisions. And it's like, do you have that same concern about like
Right.
what this is going to do to uh, a mother who is undocumented and 9 months pregnant, like, and sitting here and like, N I literally heard during the first like, right after it was issued, like, there are literal stories about, about like expectant mothers who like were talking with people about like inducing labor before the
Wow.
deadline and like getting C-sections and like, I mean, really horrifying things to think about anybody ever having to consider. And like it actually happened. And like, so it's like you've got that, you've got like these rulings on TPS and the parole, that like on the shadow docket that they just said like, oh, Kristi Noem's rulings to end these programs can go into effect while litigation is ongoing, that effectively, in both cases, 500,000 people's legal status was like just
Oof.
swept away overnight. And like there's some overlap there. And like that almost makes it more concerning in my some of the immigration lawyers are like, well, it's not necessarily a million people because there's overlap. There might be like 100,000 people overlap there. And it's like they're looking at that like as a good thing. And I'm like looking at that like as a horrible thing. Like we're dealing with a system that is so complex, so like understaffed that like they are revoking legal status for people with the an unreasoned Supreme Court opinion on the shadow docket that they don't even know how many people it's actually going to affect.
Right.
Like, and we're talking about the hundreds of thousands of people with each of those orders. Like it's just it's like, and those aren't even the merits cases. Like that it's just like really astounding to me the way that the court sort of does take, like, to your point, that they do sort of take the technicality of like, this isn't a merits decision, it's on the shadow docket, this is just talking about the likelihood of success, and we might have a different ruling when it comes
Right.
to us on the merits. And it's like, well, that won't matter if they're like shipped out to their country, because the Trump administration is also fighting to get what $45 billion to ICE next year in this bill. Like it's truly like on both ends of the two branches that are supposed to be holding the executive accountable, it's like the opposite
Right.
of, like, I've written about this several times. Like, it's sort of like what's happening right now is the opposite of what the founders expected. Because, like, the ironic thing is, like, it wasn't like somebody once on Blue Sky was like, yeah, they like wanted the balance of powers because they thought everybody would care about democracy. And I'm like, no, it was about ego. Like their whole thing was the great thing about our system is we've got states, we've got federal government, we've got three branches, and like they were talking about guys. They're like all of these guys like are going to want to be in charge.
Right.
So everybody's ego is going to keep the system in check, because there's no way a House Speaker would ever lay down and just let the president do whatever they wanted. There's no way the Chief Justice of the United States would just lay down and let
Sure.
a president do whatever he wanted. Like we're so
Right.
far outside of like what they ever imagined could be happening.
I think it's a matter of like they're all. I mean, I don't want to speak for all of their exact ideologies, but they're all sort of in this movement. Maybe Trump isn't, but basically they're using, kind of subsuming their egos to accomplish these things that for this movement that's been going on for the last 50 years.
Yeah, I mean that's certainly like Mike Johnson. I mean,
Yeah.
and obviously, like John Roberts was in the White House, and like was doing these things as a politico before he became a judge,
Right.
and like he's now going to be starting his 20th year as Chief Justice this next term. And it's like, what do you have to show for it? Like, what are you
Yeah.
doing to the Supreme Court? And if that's your metric, it's a failing. But if it's what are you doing for the Republican conservative radical movement, it might be a different answer.
Yeah, and you think about like even just sending the. I think about the ruling where they say for now they can send people to random countries, third countries, and you talk about the
That was
impact of
another one.
that.
Yeah.
Like that's people are going to be sent to third countries, like, to the South Sudan in that time,
Yep.
and they seem to like not real.
Yep.
I don't want to say they don't realize it. They seem to not care. Maybe.
Yeah. It's very. I mean, that one was truly alarming, because the one the one element of what we had seen in the aftermath of the Alien Enemies Act proclamation was this slight willingness to push back on a modicum of due process. And the most stark moment of that being when the one judge in the Northern District of Texas was the first judge not to grant a habeas injunction after they said Alien Enemies Act cases have to be brought as a habeas corpus action. And then the Southern District of Texas, a Trump appointee, granted an injunction. Southern District of New York, Western District of Texas, Western District of Pennsylvania initially. I think there was one other one, but then the Northern District of Texas didn't. And then the ACLU got wind of potential flight. They asked that judge for a stay, an injunction pending appeal, and then he denied that. They went to the Fifth Circuit. The Fifth Circuit denied that. They went to the Supreme Court, and it was like a Friday evening as they also went to Chief Judge Boasberg, who had heard in DC, who had heard the original Alien Enemies
Mhm.
Act case with sort of a Hail Mary ask for like some new class that they tried to argue unsuccessfully for. But the great thing about that was they did get a hearing, and they got DOJ on the record with some things like about when flights were taking off and when they wouldn't. And but then because they said none were happening Friday night, we waited. We didn't hear from the Supreme Court, but then at like 1:32 in the morning, we got a Supreme Court order, and the
Yeah.
Supreme Court issued an injunction, issued a putative class injunction. Like, this district court judge hadn't granted a class, and the Supreme Court said until this is worked out, no flights are taking off from the Northern District of Texas under the Alien Enemies Act. And like that sort of, they upheld that later on sort of the merits of that shadow docket request, not on a merits case, but on the actual shadow docket request. And that was 7-2. And so we had this like feeling that like when it came to, you need to at least give basic due
Mhm.
process to people before you deport them, we thought we were getting somewhere. And that is all that Judge Murphy had issued in the country removals case. And the Supreme Court said no to that. And we only got 3 dissent. We didn't get, we just got the Democratic appointees
Yeah.
dissenting. And that to me is rather alarming. I think the very narrow read, but the only possible like rationalization of the difference for that is that like they were still being removed under the INA there,
Mhm.
under the Immigration Nationalization Act, and you're allowed to be removed to a third country um, if you're given notice. And essentially, Murphy was saying you're not being given enough notice.
Okay.
And so the argument is that the INA was passed by Congress. They didn't set forth any set standard. And so the court, aren't going to judge that as
Mhm.
harshly because anybody who's getting a third country removal already has a notice of removal. They've already been approved for deportation. They
Eh,
just, for some reason, they aren't being able to be removed to like, if you don't know what third country removal is, what it means is the first country is your country of origin. The second country is another country where you have legal status. And so the idea of third country removal is it's basically not one of those first two, but it's the actual legal ideas is it's a country that you have no legal affiliation with either by
it's like
birth or status.
And they're sending them to like dangerous countries too. They're not just sending people
Well,
to like
yeah,
a
the
nice
that's
European.
the
Yeah,
reason why it
yeah,
got Murphy's,
yeah,
why he issued these stays. He had also issued another clarification of his injunction when they tried to send people to Libya. Like, and so, like, I am really alarmed by that, and I'm still in my like looking for the. We don't even have any ice cubes in this situation,
yeah.
but I'm looking for at least some room temperature rain falling on the boiling water.
It's
Um,
psychotic.
and
It's sick.
the only like even room temperature water we have there is this idea that like whoever is controlling amongst the Republican appointees to get the majorities that they're getting on the Alien Enemies Act due process arguments, that they're able to get 7 votes, um, is differentiating these cases because they're saying they have notice of removals. They, um, the only difference is that they're being removed to a different country.
Yeah, I mean,
And
the
that,
mental gymnastics these people must make.
yeah, I don't agree with the
Bro,
mental
for sure, of course,
gymnastics.
of course, of course.
I mean, one of the justices who I already disagree with half of what they say
Yeah,
is is reaching is somehow reaching those gymnastics.
yeah,
Um,
it's remarkable. The one
on
thing,
the shadow docket, they might feel differently on the merits, as they would always tell us.
yeah, and then there's like thousands of people who are suddenly stuck in South Sudan. In the meantime, but I wanted to ask you also one of the cases that they did not decide was a voting rights case. They want to have more hearings on that or more arguments, and that is a huge one. And I don't. They've obviously chipped away at the Voting Rights Act. The one thing that's remaining, I guess, is the if it's a blatant racism that stops that causes gerrymandering or what have you. And now this is it seems like, are they waiting for more evidence so they can rule against it? Or what do
Yeah,
you think?
this is this question of does like Section 2 of the Voting Rights Act, which is essentially all that's left after Shelby County to really force compliance in it, as opposed to what you used to have under Section 5, which meant in the states that had a history of discrimination, you had to get pre-clearance before
Right.
you made any changes to your districts, your voting practices. That was gone under Shelby County. And what you now have is Section 2, where DOJ can bring lawsuits, but also other entities and individuals can bring lawsuits. And you can challenge districts primarily for what's called vote dilution, where Black voters' votes are being diluted
Mhm.
or other minority groups. And the question that is now being raised in these cases and other is um, does the remedy in Section 2 cases violate the Equal Protection Clause of the 14th Amendment?
The
Which,
anti-white
like,
racism.
the easy answer is obviously not. It's the Voting Rights Act. It was create like everybody who passed it. Like you want to go back to like everything that our dear friend Clarence Thomas would think of. Like obviously everybody like who passed the Voting Rights Act thought that this would not be the way that it could never be unconstitutional under the 14th Amendment. But he's going to tell us that back in the post Civil War era, that they would have thought that this was abhorrent. And the um, essentially, Justice Thomas said, "Why didn't we do that today?"
Right.
Um, and even though they set it for re-argument, he dissented and wrote a brief opinion saying, like, for over 3 decades, I have said that we need to rethink this, and he's hopeful the court will soon realize the conflict that Section 2 jurisprudence has sown with the Constitution and that it's now too severe to ignore. So he's he's hoping for it. I would say the odds are this this ruling meant that they couldn't find 5 votes for any solution. That
Mm,
whatever middle ground Roberts or whoever was trying to create was too far away from what we have now for to get any of the Democratic appointees.
mm,
And I would imagine that honestly, even though only Thomas wrote this, he wrote it because he was saying for over 3 decades. Um,
right.
but I would imagine that Gorsuch and Alito were with him
Mhm,
on this path. And it was a real question about, I mean, Kavanaugh and the Chiefs were probably trying to create something in the middle there. And they couldn't get a middle,
right.
and this was the way of I mean, it wasn't splitting the baby, it was kicking the can down the road. And I think it pissed Thomas off that another year passed without his dream of the end of Section 2 not coming to fruition.
I wanted to ask, and I wanna ask I don't wanna take too much more of your time, but I wanted to ask, do you bring
Which,
up
I
Justice
mean, like,
Thomas?
let's be clear, I hate to say this, but in the like Ice Cube, my new Ice Cube
Yeah,
analogy, which I clearly need to write about, um, because I keep returning to it, um, like like that's what counts for a win today.
right. Not a
Like
total loss,
like
yeah.
if the if I mean if Jackson and Sotomayor and Kagan were able to keep a majority, they were able to keep um I mean, if they were like, let's assume one of like, even let's assume Barrett went with those other three,
Mhm,
they were able to keep Roberts and Kavanaugh strong and keep neither of them. I mean, like, think of it as like what we already know about some of what was going on behind the scenes with
right,
Dobbs and Roe.
yeah,
Like, this is essentially what, like, I mean, my belief is that uh, uh, a far right person leaked the draft to lock in
oh,
those 5
Dobbs, yeah,
votes on Dobbs. Like, this is essentially the worst nightmare from the right on Dobbs. Like,
yeah.
it came to fruition. Like, this is essentially Roberts' middle ground concurrence in Dobbs winning.
Right. Yeah, no, it's scary to think what could happen, and, you wonder, like, they have become so, emboldened. You mentioned the Clarence Thomas thing, what he wrote today, and this was kind of like my pet obsession, the last couple of years, so maybe I'm just reading into it too much, but just the lack of any sort of, investigation into all the corruption that happened at the Supreme Court. The clear amount, Leonard Leo, all those guys, the guy who collected
Oh,
Nazi
yeah.
statues, like, do you feel like they've been emboldened because they feel nothing's gonna happen to them now? It felt like maybe they're, we've been a little bit,
I
taken
think
down a
there's a
notch by some of
I
that,
think
but
there's I think it's a combination of like emboldened and like, I mean, this was the first year of a new term.
yeah,
And so, like, it's sort of like, I mean, to show how political they're getting, it's sort of like how we always talk about like a president wants to get like their biggest things done in their first year because
mhm,
that's the only time they really have clear power. Because already in the second year, members of Congress are working on
mhm,
reelection. Like, I think this was an example of seeing that in the Supreme Court with what we saw this year. Is that like, I mean, you've got a combination of empowered and like it's the first year of a new term, so they're sort of free, and you've got the thing that they clearly learned from. I mean, strangely from the other side from Ginsburg's death that you have to take your majority when you get it and
yeah,
get done what you can while you've got the votes. And like, I think after, especially for the furthest right Republicans on the court, like they all are, but like the furthest right, like they learned from Roe, like, or from Dobbs and Roe, like we can lose one vote even and still win.
right.
And we're okay with that. they're okay with a 5-4 win that Roberts or Gorsuch or Kavanaugh or Barrett joins the liberals on. They're still writing it. I mean, what was it? Barrett wrote that dissent in the EPA case last year. Like, they didn't care. It was still a dissent. Like, it was 5-4. Like, go do your dissent, Amy. Like, we're
Right.
still like polluting the waters, or I forget if that was a water or air case. I think it was a water case, but
Yeah, and they know that there's politically no one's going to touch them, right? They can go be as corrupt as they want. They can go say whatever they want. They can go make speeches, swag around, and nothing's going to stop them because there's been no investigations, no nothing or consequences.
yeah, there's now no branch currently right now.
Yeah,
Um, like nobody's going to hold hearings. You're going to have. I mean, you're going to have Ron Wyden and Sheldon Whitehouse like yelling,
right.
and like
One Dick
that's
Durbin.
great, and we want that. Notice who I name.
Yeah,
Um, I mean, Dick Durbin, yeah, yes. I mean, he's done some good things. And I mean, yeah. Um, and I
in
mean,
his long career,
and
sure.
Warren will do her things despite not being on judiciary. Like, I mean, we do still get some pushback, and like there are still like things that happen. But like the fact of the matter is, yeah, it looks a lot different when you know you're not going to be getting a a letter signed from the chair of the Senate Judiciary Committee
Right,
and the chair of the Subcommittee on Constitution than when like the ranking member is going to send something. And like if they even are, like what's
right.
the point?
Yeah, exactly. Yeah, I
You
wanted
don't
to
even have the threat of holding a hearing.
exactly. Yeah, no, there's no investigation, nothing. I wanted to. So we had a lot of questions people were asking during, while we were talking, and so I want to give people a chance to like, make sure that we're not ignoring them if they want to ask them again because there's some really good ones. So if you've
Yeah.
got a question, for Chris, please, ask it now. And so while we wait for those, last question for me is, all right. So the summer, it's kind of the summer a little bit. We'll get there soon. Um, then the new term starts in the fall. We just talked about the voting rights case. What other things should we be thinking about,
Oh,
worrying
there's
about, looking
so much.
towards?
Here's the worst reality that I need to just be honest. Like I truly just like sort of look in abject horror at the coming term. Like no matter what, like this was the case back at BuzzFeed. Like I have like I mean I'm still like I've got like I mean this is my like cases like as I read them, and
Organized.
this is Mahmood, which I still haven't published. Like, I'm gonna be writing about Mahmood, and like it's like I still I like we've still got the shadow docket this summer. We still don't have the cases over government rifts. We've got
Yeah,
both the government wide rift case out of California and the education department rift
right.
out of I think it was Massachusetts, that are both pending on the shadow docket. And I think the government wide one has been pending since the beginning of June. The education one has been pending since mid June. And it's like, I also, as you know, like since back in my BuzzFeed days, also like focus, like try to cover the executions as they
Yeah,
come up. And while those are much less likely to get any surprising result under this court,
of course.
I still do cover them because random things do sometimes happen. I mean, like Richard Glossop got a new trial
Yeah,
after at long last. But I think that, like, I mean, we today, like the Supreme Court did grant cert in another big campaign finance case
hmm
about like joint party
that
spending
was concerning.
um,
Concerning.
that the Republicans brought to the court. So that's going to be heard next term. There is especially in light of what we've seen from the court this term, a really concerning grant about conversion therapy bans that the court had denied cert a lot of times in those
Feels that's like
cases, and they
2004. That
granted
stuff.
cert in earlier this year. There are doubtless going to be more immigration and criminal law cases that are going to be concerning. Um, I don't even know what else is on the docket other
Yeah.
than those two big cases. But also remember, like, even when I did like my beginning of term, like podcast discussions and stuff last year, like 90% of the big
Right.
cases weren't on the docket yet.
Right.
Um, like Scrimeti was on the docket, but that was really one of the only big cases on
We
the
didn't even talk
docket
about
at the
that one.
start
That's
of last term.
another atrocity.
Yeah, I mean, Scrimeti obviously is like horrible decision. That was another one where like the court didn't technically even rule on what level of scrutiny should apply to
Yeah.
transgender status based discrimination, because they instead found that this law that like if you asked 100 people in Tennessee who it targeted, they would tell you transgender people.
Of course. Yeah.
Like, yet the Supreme Court said, no, this wasn't a classification based on transgender
The people who
status.
get this treatment are transgender, but
Yeah,
it's
I
the
mean,
treatment they need.
it was like, I mean, it was also just an abhorrent decision on like the fact that they said it wasn't a sex classification.
Right.
And so, therefore, essentially, because of that, they decided you only need to prove a rational basis. And so, because of that, we got this even more offensive decision that essentially said they didn't even look at the whether or not the reasoning of for doing this was a basis. They said the Tennessee legislature said that there was like a dispute over this.
Right.
And that dispute is enough to be a rational basis. And so like you don't even need to put forth evidence that something is that there is a need for this. They didn't need to prove that this care is harmful, that this care is causing any harm, that this
Right.
care is unnecessary. All that they needed to show was that they believed there was a dispute over
Right.
this.
Yeah. Some bigots say this, and so it counts.
Right, which was a self-propagated
Right.
dispute. Like
Sure.
there was no
They
dispute
created a
before
dispute.
they decided to make it a dispute.
Yeah.
They made it a dispute. Then lawmakers used those articles and discussions and debates to say there was a dispute. And then John Roberts said, "Oh, there's a dispute."
Right. Yeah. You can pick a fight and then say, "Hey, look, it's a fight." So solve it.
So in some ways, it like is very horrible for gender affirming care for trans minors. They did say that like the fact that it was under 18 was a key aspect of this. So like they left that out. They also didn't resolve the parental rights claims, and they denied cert in those today. So those remain out there. They also didn't decide when there is a gendered based status, what level of scrutiny it resolves, and when there is an anti-trans thing that is sex discrimination, how that should be resolved. So there are the upside I just like to give people is that there are still arguments
Hmm.
for lawyers to make in anti-trans cases, particularly where there is evidence of animus that they are bringing,
Mm.
that there is a bare desire to harm the group.
Some of that.
Um,
So
which like you
all of
might
it, but
look
yeah.
at the Tennessee law and say like, well, there was, but
Right.
like that wasn't the argument in that case, because bluntly they were able to win on this other standard,
Sure.
and they did win at the district court
Right. Yeah.
in
They
both
didn't.
Tennessee and Kentucky.
Which should be obvious that this is clearly discrimination. They thought they'd win on
Yeah.
that, so it didn't make. Yeah, it totally makes sense. Well, I'm glad that you are looking for the ice cubes. You're looking for the lukewarm raindrops to go into this boiling
Yeah.
water because keeps me keeps me it keeps me a little bit sane, I guess, as this stuff going on. But like I said, I'm amazed by the amount you put out and the way you help us understand it. Because it's so much. Even people who follow politics, who follow this stuff, it's like it comes out so fast and it comes out so rapid and
No, there's too much. I mean, there's too much for me. Like, I mean, literally most days, like I spend an inordinate amount of time opening my court alert emails that are just filings in cases. Like I
yeah,
literally probably spend 20 minutes a day opening emails, like not even like reviewing filings if they're
right.
relevant, but just opening emails because there are so many cases that I'm tracking. But like it's the same thing on the other side. Like, I mean, I said today, like about the bill,
Right.
like I posted on Blue Sky, like, this is horrible, there's bad, like you should be paying attention to it. I used to cover Congress, but I am not the person that you want like posting about what you need to be paying attention to for this because I don't know anymore because I'm too stuck in my own weeds to be
It moves so
following those
fast.
weeds.
Even the senators didn't know it was in the bill at some point
Well,
today.
yeah, there's that.
Yeah, I don't think they cared, but well, listen, Chris, I will let you get going because you were very generous with your time tonight. You probably need some sleep. It's been a crazy, crazy day of reading and writing, crazy weekend. And thank you so much. Where can people find? I mean, I'm sure a lot of
Yeah,
your people read it or watching this, but where
Lodork.
can they find it?
Find me Lawdork. I'm most active outside of Lawdork on Substack, on Blue Sky, Chris Geidner. You can find me pretty easily on Blue Sky because I'm luckily one of those early adopters
Yeah, you're
who
smart.
has a lot of people there. And that is my main platform other than Lawdork. But subscribe to Lawdork here. I do often post in chat at Lawdork when things are happening live. So something that you get if you do subscribe. Almost all of my news is free. I do occasional benefits for the paid subscribers who help keep me afloat. But in terms of all of the breaking news and all of that, that's always free. So
As Holy
sign
Cannoli
up.
says, subscribe. You won't regret it.
There you go. Can't get a better prompt than a holy cannoli.
Absolutely. I would talk to you all night, but I'll let you go. We'll do this again soon. Thank you so much, Chris.
Thanks a lot, Jordan.
Take care.